Good morning, everybody. Welcome again to our Legal Issues Committee, the latest webinar sponsored by Weiner, Brodsky, Kiter. Thank you guys all for joining us today. We've got an interesting program set up. We're going to have an update on the CFPB's recent guidance by Ken Markison from Weiner, Brodsky, a update on the HMDA rulemaking by Rich Andreano from Ballard, Spahr, as well as an update on where negligence is in California. It's been a hot topic for a number of years, and it's finally starting to tip in the lender's favor. We'll also have an opportunity for some Q&A as well as a legislative update from Dustin. Before we get into the program and hear from our sponsor, I do want to mention one thing, and that is this Legal Issues Committee is incredibly important for all of its members. Of course, you all are attending because of the importance, and a lot of fun things happen through it. But it's also driven in large part by everyone's participation. We, prior to these webinars, schedule these webinars and develop them through a business meeting of the Legal Issues Committee where we decide on what topics are most important and most pressing that need to be discussed. If you all want to participate and have some ideas of what needs to be discussed at the next webinar, please reach out to Dustin or myself. We'd be happy and welcome you at the next business meeting to talk about some potential ideas. As well as if you just don't want to attend the business meeting, but you have some ideas, again, please feel free to reach out to us. Of course, these webinars could not really happen without the sponsorship of the California MBA and, of course, the wonderful firm Weiner Brodsky. Ken, why don't you tell us a little bit about your firm?
Well, thanks very much. This is Ken Markison. I'm of counsel at Weiner Brodsky Kiter in Washington. I think as many of you know, WBK is a full-service national law firm that advises on federal and state laws affecting the industry. We have particularly deep expertise in federal regulations and in developing advocacy strategies, including preparing comment letters on these rules as they develop on behalf of industry companies and associations. For this reason, and of course our appreciation of the very high quality of the California MBA's work, we're delighted to participate in, and of course are very pleased to sponsor this webinar, which we look forward to as a good discussion and review of the regulatory to come from the CFPB. I should say the regulatory world to come. Thanks.
Excellent. Thank you so much, Ken. We really appreciate that. And up next is our legislative update from Dustin.
All right, thanks, Jared. So we've got we're right sort of at a pause point in the California legislative session right now. The legislature is out now for a month of recess, and so things will be, I guess, from many of your perspectives, and certainly mine, it's kind of nice when the legislature is out and it, sort of the legislative fires are put on hold for a month. And so we're right at the beginning of that phase, so there won't be much movement on the bills that I'll mention here for another month or so. But if you want a fuller discussion of where we're at with a lot of the bills, I'm only going to mention a couple here, but I'll go through a fuller list at our next business meeting next month. So again, as to echo what Jared said, if you're interested, if you're a member of the California MBA and interested in joining us on that call, please let me know. And our contact information you'll find at the end of this webinar. So the two bills I mentioned, I'll start with AB 25. This is a bill that the California MBA and a lot of business groups in the industry and within the state support. This is an update to the CCPA that passed last year, and as I think everyone probably on this call knows, that bill was passed very much in haste and with a lot of unresolved issues. And this is one of the bills that we think is doing a good job of at least fixing one tiny aspect of the law that is, caused a lot of consternation for folks on this call. And so this bill would make adjustments to how the law defines a consumer related to employers. So if you see there on the screen, the bill would exclude from the definition of consumer a natural person whose personal information has been collected by a business in the course of the person either acting as a job applicant or as an employee or a contractor or an agent on behalf of the business. And so that, I think that for a lot of folks, that was one of those head scratchers as to why that didn't get fixed last year. And so this bill, if it passes, that will hopefully solve that issue, and then we can move on to some other issues. The good news on this bill is that from what we understand in the last committee hearing, a lot of the opponents of this bill have since removed their opposition, and so the bill, we have good a good lookout for this bill going forward. It looks like it is going to pass and be signed into law. So it's on a glide path at this point. So we're pretty excited about that. The next one I'll mention, this one's not quite so much as good news as AB 25. That's AB 1482. Both bills, incidentally, are at this point in Senate Appropriations Committee. They both passed out of the original House, out of the Assembly, and they're going through committee process in the Senate right now. This bill is a rent control bill. This would sort of blow up some of the protections of the Costa-Hawkins Rental Housing Act that passed many years ago. And this would place rent caps on most rental housing in the state, and that would also mandate that owners list a just cause if they wish to terminate a tenancy. So you can see in the in sort of the language there, there's a lot of problems with this. So the California MBA and the Chamber of Commerce and many other groups in the industry, the Apartment Association, Business Properties Association, the California Taxpayers Association, those are all groups that are strongly opposing 1482. Sort of the bad news is that it's looking pretty strong right now. If I had to judge this objectively, I'd say this has an excellent chance of passing, and then it's in the hands of Governor Newsom. And honestly, we're sort of unsure. He's signaled in the past that he would be amenable to rent control measures, but he also has made it clear that he wants to call for more construction of housing units. And so from our perspective, it's kind of hard to square those two things up. So we're hoping that the bill will either be defeated in the committee proceedings here in the Senate, or if it has to, and be vetoed by Governor Newsom. So as I mentioned earlier, I'll be going through a fuller discussion on these bills on our August members only call. And then if you have any other questions in between, you can certainly shoot me an email. It's dustin@cmba.com, and I'd be happy to answer any of your questions. As well as at the end of the presentations today during the Q&A. If you've got a specific question about the bill, I can do my best to either answer your question or follow up later. So Jared, that's all I've got. I'll hand the ball back to you.
Excellent. Thank you so much, Dustin. It's always helpful to hear what's going on up in Sacramento. Now let's hear a little bit about what's happening out in Washington. Ken is going to be giving us some guidance on what the CFPB has recently done. Ken, take it away.
Thank you very much again. What we're going to talk about today is the CFPB's latest regulatory agenda. It's hard to pinpoint just because of the dates on some of the documents, but generally it came out in May, and it covers the period of the next year through April, and we'll talk about what that means. Next slide, please. This is me. This is my bio. We can move on from here. Well, let me give you this bit of background. The Bureau, as an independent agency, nonetheless voluntarily participates in what's known as the executive branch's unified agenda of both regulatory and deregulatory actions. These lists for all of the agencies, including the CFPB, are published in the Federal Register. What is published specifically is a pre-rule list of active rules, a proposed rule, and a final rule stage action. All of that's published together. Then there's a separate listing of what's known as long-term actions, and finally a listing of completed actions. If you go to the website of the CFPB, you can access these lists, and if you click on the list, you'll get some description of what's intended and what the Bureau is thinking about. Now, there is a preamble, which is designated supplementary information, that prefaces the agenda, discusses the entries, and I think more importantly, provides some context. Next slide, please. When we look at the supplementary information or preamble, there's an introduction that gives you some overview of the Bureau. There is a division of the conversation into 3 points at this point at least, or 3 parts. First, they think of the rules that are implementing statutory directives. The next thing is they group the rules that they regard as continuation of other rulemakings. And then, interestingly, they talk a bit about new projects and further planning. Next slide, please. Okay, the introduction points out something that I know you've heard, that perhaps you haven't heard this term, that the director, who is new, of course, has been on a, quote, listening tour, engaging with stakeholders, including from our industry, employees, and a bevy of outside experts, building on the feedback from what they call the Call for Evidence, or RFI initiative. Now, this, you'll recall, was a series of requests for information that was initiated by Acting Director Mulvaney for the purpose of giving a critical look at the Bureau's operations to date. And it was organized into 12 separate requests for comments. It really is stunning that there were 88,000 comments on these in response to what mostly were questions about how the Bureau was doing. So building on that body of knowledge and then talking, it's clear that the Bureau's come to some conclusions, at least for now, and I would expect in the future, on what the direction will be. The next piece is that the agenda, they caution, reflects ongoing activities, but they indicate there is concern about the potential sunset of statutory and regulatory provisions. And here it's pretty clear when you dig into this that they're talking about the so-called GSE QM patch. Now, we'll get to that again in a minute when we get into the rules, and we'll talk about what that is and what the ramifications might be. Next slide, please. Okay, so far as implementing statutory directives, a key piece that fell into the CFPB's agenda is that the Economic Growth and Regulatory Relief and Consumer Protection Act of 2018, which is a lot of words, but an acronym that goes AGRIPA, it was enacted last year, May of 2018, and it touched on several aspects of rules that the CFPB was responsible for, or that it made the CFPB responsible for. An important one, which is, according to the agenda, and we know at the pre-rule stage, that is, there has been issued an advance notice of proposed rulemaking to garner comments about what approach the government should take. What it's asking about is what standards are appropriate to apply the ability to repay requirements, which of course are part of the ability to repay rule to PACE loans, that is energy loans. And the other piece is how do they, having been instructed by the statute, apply the civil liability provisions to go along with the ability to repay requirements to PACE loans. Big issue, big concern to that industry, and certainly to our industry as well. Also in the pre-rule stage, in the category of statutory directives, is Agrippa, if I'm pronouncing it right. It's actually directed that creditors with assets of $10 billion or less be accepted from the higher priced mortgage loan escrow requirements under Dodd-Frank. Next slide. Continuation of other rulemakings. We may have jumped one slide too many. Can you go back? There are, as part of this initial implementation of last year's law, there is a HMDA provision, which I know Rich will be touching on, that would create exemptions and is a continuing process of looking at the exemptions and thresholds for HMDA's coverage. It notes that in the future, the Bureau will also doing some rulemaking, even in cases where regulations became effective under Agrippa without the Bureau's tutelage, in order to conform them to the body of rules that already apply. A good example is that under the new law, there is a small institution qualified mortgage. It has standards in the legislation, but there is no requirement for the Bureau to actually regulate. The question, though, as the reader, is when you go into the regulations applicable to QM, you don't find it. So the question is, how can rules like that exist today absorb these new self-executing provisions and conform them so someone looking at the law would understand how they work together? The preamble, by the way, highlights that there were several other activities in implementing last year's law, including updating small entity compliance guides, which would not generally fit within the regulatory agenda's framework. Finally, another point to note is that the Bureau clearly is getting around to implementing, again, or restarting a process to implement 1071 of Dodd-Frank, which amended ECOA, the Equal Credit Opportunity Act, to require institutions to collect, report, and make public data on applications for financing from women-owned, minority, and small businesses. One can imagine that the HMDA experience at this time will certainly affect this process, and I would expect that those institutions that are involved in lending to these businesses and have mortgage businesses will be particularly interested in sharing information. Next slide. Okay, continuation of the rulemakings. Again, there's HMDA and HMDA twice. There has been an advance notice of proposed rulemaking to look at HMDA data points and look at them critically with an eye to whether all of it is needed. There's similarly some information on the disclosure. I don't mean information, but new guidance regulations coming around disclosure policy. Again, I leave that to Rich. Communication practices, sounds like debt collection is very much on their screen. And I think for our servicers, there will be activity there. Finally, the payday rule is a continuing activity, although it may not be of interest so much to our members or to our industry. It certainly has consumed a lot of energy at the Bureau. Next slide, please. Well, the interesting piece, for me at least, is what's ahead. What are the new projects the Bureau's thinking about? And what I alluded to before, the GSE patch is particularly important. That again extends QM status to loans which are eligible for Fannie or Freddie purchase or guarantee while they operate under conservatorship or until January 2021. This is a hot button. There are a lot of folks, including those who would like to see a different sort of approach to the GSEs, a more privatized approach, a less governmental tie approach, who want to sever this standard and not essentially embed the GSE standards in QM. There are others who believe very strongly that this is an efficient, automated method of deciding borrowers' qualifications for good loans. I think these two forces are bound to collide somewhat in this discussion. And this discussion, because of the expiration date of the patch, is very timely. And I would personally expect that there will be a good deal of activity around that. TRID is coming up for assessment. That is, the 5-year clock is running so that Dodd-Frank requires that there be a new evaluation of the TRID rule. And I think that's going to be an important activity, particularly to those companies, and there are many of them, who would like to see some change. Some might even want some additions to the rule, and that's where that conversation will be. Remittance rule, monitoring markets, suffice to say that monitoring the markets gives an opening, and the Bureau notes it, for further action in areas we haven't really talked about today. Next slide, please. That's the point of it. With an agenda, there is a good listing and a robust listing, but it is not confining, meaning there can be new concerns, new ideas, new problems that get added to the regulatory workload. That happened last year with no action letter guidance and policies. We might expect or be sure that there'll be some unknowns added to the list as well. When I think about it, the issue of disparate impact and conforming it to the tests and the rules to the Supreme Court jurisprudence on these tests would possibly be something we'll see. I think another point is that MBA has rightly been pushing for some modifications to the LO comp rule around mistakes by loan officers, price match competition, and why it's restricted by the rule. All of these areas are areas that MBA would like to see tackled. It's very possible that one or more will be. Finally, further action on any of the RFIs, and I've listed them all in the appendix, I think, not only a possibility, but can be expected. Let's look finally at this last list, next slide, which is the down the road list. I indicated long-term actions are listed by the Bureau. This includes the review of inherited regulations. Think of RESPA and its relatively ancient pronouncements on Section 8. FIREA was amended. There's an interagency effort to address automated valuation models, or AVMs. Abusive acts and practices. We've seen a symposium recently on the subject. The Bureau lists it as an area where rulemaking may well be needed to define it further, and so on. I think this list even ends on a revisiting of the consumer reporting standards, which implicate the credit reporting agencies and repositories. Next slide. So closing, this is a robust agenda. I think anyone who is calling the Bureau dead or dying is mistaken. I think for all of us, there's some very significant issues about the patch, about how TRID might be changed, how PACE might work in terms of our markets, HMDA burden and risks, and of course RESPA and others that need overhaul, including PILA. I expect that these issues will, as you would expect, garner very significant comments from not only our industry, but advocates, government, and others. It really is the area where there'll be some very hot and divergent views. I would suggest that whether you work with a law firm or others or your industry groups, it really is the time to start thinking about that to make sure your views are well considered. The next slide, please. As promised, these are the appendices. They are the listing of the RFIs, requests for information. In the interest of time, I'm not going to go through each, but what you see is a very wide-ranging picture of various parts and activities of the Bureau. I suggest that they are the commentary that will, in part, drive the discussion along with the agenda for years to come. Thanks very much. I look forward to your questions.
Excellent. Thank you so much, Ken. And following up on that, we will have a presentation from Rich Andreano about HMDA. Rich, go ahead.
Thank you very much. And as Ken indicated, there is some HMDA rulemaking going on, and that's what we'll take a look at. If we go to the next slide, there are really two items, and these were telegraphed fairly clearly, both by Acting Director Mulvaney in various statements he made, and as Ken noted, also in their regulatory agenda. And what the Bureau did is really took a two-prong approach. One is a proposed rule. The other is an advance notice of proposed rulemaking. They both were posted May 2nd on the Bureau's website. The advance notice of proposed rulemaking appeared in the May 8th Federal Register with a July 8th comment deadline. That has since been extended to October 15th there. So, and that, if you're looking for that extension, that appeared in the July 3rd Federal Register. They decided to give more time because of the significance of what's being considered. The proposed rule, relatively quick, appeared in the May 13th Federal Register with a June 12 deadline. And significant with the proposed rule, this is something, I think this is the second time the Bureau did this. They included with the proposal various helpful materials, and one was actually an unofficial red line of the way Regulation C, the HMDA rule, would be amended by the proposals. You actually could see the actual wording change, and it made it much easier to see what was actually going to happen. So they've given some indication that these are things they intend to do going forward with proposals. And I think this is things when we provide comments, we should applaud them for doing this, because this is very helpful. And when they do something helpful, I think we should applaud them. Now, what the proposed rule would do is two main things. The first thing is addressing the triggers for who is a HMDA reporting entity. You might remember when the rule was revised, it set the trigger for both depository and non-depository institutions at least 25 closed-end loans in each of the prior 2 years. Before, the trigger for banks essentially was one loan plus certain other factors. For non-banks, it was 100, and this brought it to 25. Greatly expanded number of entities who had to report, and continued reporting by some other entities who really didn't make that many loans. So what the Bureau has proposed is taking that 25 number and moving it to 50. So it would have to be at least 50 loans each of the past 2 years. But it optionally also requested comment on going to the 100 level, which was used before for non-banks. But whatever they do, this will be uniform for banks and non-banks, at least the way the proposal is. Secondly, if you remember what the revised HMDA rule did, is it added home equity line reporting as mandatory. Previously, it was voluntary. And they set the trigger originally at only 100 credit lines in each of the prior 2 years. Relatively soon, the Bureau itself realized that that was probably too low. And so even when Director Cordray was there, what they did was temporarily raise the limit for a couple of years to 500 lines in each of the prior 2 years to give the Bureau time to study the issue. So what this proposal is to extend that temporary 500 limit for an additional 2 years, and then set the limit permanently at 200 lines in each of the prior 2 years. And frankly, if Cordray was probably still director, I'm not so sure that number's different from what would have been proposed from the Bureau then. A lot of criticism, there were a lot of knee-jerk reactions that this would substantially cut back on HMDA reporting, exempt people from fair lending laws, a lot of misinformation, and that's why we as an industry need to, through the California MBA and other ways, engage in our advocacy to confront that, to get our voice heard that no, this is intending to balance the limits of regulatory burden in a cost benefit away, and this isn't exempting people from fair lending laws, which is a claim you hear from a lot of consumer groups. Now let's look on the next slide, please, at what the other thing the proposed rule would do. As Ken would mention, the Growth Act, which was passed last year, included an exemption, and it was for small banks and banks and credit unions that were lower volume. What's lower volume? Fewer than 500 loans or closed-end loans, or 500 HELOCs in each of the preceding 2 years. That would be low. So if you didn't hit the HELOC trigger, but you hit the closed-end trigger, then you'd have reduced reporting. And what the reduced reporting was intended to do, and it wasn't perfect, but the basic thought of Congress was make these institutions report the historical HMDA categories, but not the new HMDA categories, because there was a great expansion in the October 2015 rule. Well, it's easy concept, but sometimes some things are easier said than done. The Bureau itself had to really go through each of the categories and identify which qualified for the exemption and which didn't. And then they had to come up with a mechanism, if you qualified for the exemption, exactly what do you do. So it issued an interpretive rule last September. And what the proposal is now is to take that interpretive rule and insert it into Reg C. Basically, what it does, if an institution qualifies and wants to rely on the exemption, for each applicable code, the Bureau came up, data field rather, the Bureau came up with a code that indicates they're exempt, and they would insert that code. They could still elect to report, because what if you're right around the level every year and right around the 500 level? You might decide it's just easier to report everything, and that way you don't have to assess each year whether to cut back or not. So that's open. If you elect not to report a universal loan identifier, you then have to report a non-universal loan identifier, more like the old application number. Now, There is a condition on this, though, and this was placed by Congress, that they didn't want someone to qualify for this lower reporting threshold if they were having some CRA, Community Reporting Act issues. Now, what here is needs to improve, a rating of needs to improve in this area in the prior to reports, Community Reinvestment Act reports, would disqualify you, or in the most recent report, a rating of substantial noncompliance would disqualify you. So that's where they put some conditions on meeting it in addition to volume. What about timing? When do I think we'll see this final rule? I think the Bureau wants to move quickly on this one, particularly because of the threshold. I think it wants to get those revised thresholds in effect as of January 1, 2020. So I think looking late summer, early fall for a final rule there, that's probably, I think, the time frame that we're looking at. Let's go on to the next slide, and now we'll turn to the advance notice of proposed rulemaking. Now, the fact that Director Kraninger decided to go with an advance notice of proposed rulemaking rather than just proposing changes to data categories, I think reflects partially she is going to be very methodical in how she goes about things. It also helps to mute criticism. If the Bureau just came out and on its own assessment decided to remove or adjust categories, subject to a lot of criticism that they had predetermined what they were going to do. By taking this advance notice of proposed rulemaking approach and soliciting comment from interested parties and then formulating a proposed rule, because that's what they will do after this, it really says, no, we haven't predetermined anything. We're really going to look at all the views of both sides. But importantly, as you'll see, they're requesting a lot of cost-benefit type of input, which will allow the Bureau to say, well, this data point is helpful, but the cost simply outweighs the helpfulness. So I think we're going to see that. Now, what they're going to do is focus on, Congress added itself some data points in Dodd-Frank and authorized the Bureau to add more. And boy, did they add more. We'll see shortly how many they added. They added more than Congress added itself. So they're going to look at the new data points that that the Bureau added based on the discretionary authority. Plus, the rule, as we know, has various free-form text fields, some that institutions complete in certain situations and some that consumers can complete. We'll focus on that in a moment. Third, this is important for multifamily, particularly non-bank multifamily lenders. Now, changing the reporting threshold alone will knock a lot of non-bank reporting multifamily reporters out of the reporting category. But here, they want to actually look at the application of the rule to a business or commercial purpose loan made to a non-natural person, in other words, an entity, and secured by multifamily dwelling. They're really deciding, should these be reported at all under HMDA, regardless of how many of these loans you make. So that's what the advance notice proposed rulemaking is addressing. Now let's look at the next slide. As I noted, the Bureau added a number of data points under its discretionary authority. Here are all of the data points. As you can see, that is quite a few data points, and there were a lot of burdens as a result from that, having to collect all this information from your LOF, get it into the HMDA reporting format, and then get it over to the Bureau. This was not an easy lift to getting all of these items in there. And remember, the Bureau also modified some categories too. So, and those really are, as we'll see in a moment, on the list as well. So these are the particular items that the Bureau is seeking comment on in this. Now, as to freeform text fields, let's look at the next slide. What the rule did is lenders in certain cases would have to enter freeform text. For instance, if the denial reason isn't one of the standard reasons and you selected other, you have to enter the reason in the freeform text field. Automated underwriting system, if you selected other, it's not one of the pre-populated ones, you'd enter in the freeform text field. Same with the result when you select other. Now it's interesting, as this rule is going through implementation, when I come across a statistical firm in general, and this wasn't just done in the HMDA universe, but I just said, hey, when the government or someone in general collects information from consumers and they use a free-form text field, so it's not a company filling it out according to specific rules, it's just a consumer filling in whatever they want. how would you describe the results of that from a data analytics standpoint? And interestingly, they all gave me a one-word response, and the one-word response was garbage, that the results are garbage. So it'd be real interesting to see here what happens. Now, here's where applicants can actually enter information. In the subcategories that were added to Hispanic or Latino, there are some specified subcategories, but the consumer also has an ability basically to do an other and enter a non-specified subcategory in a free-form text field. Same with individuals who indicate they're American Indian or Alaska Native, they can enter a tribe in a free-form text field. Finally, the Asian, Native Hawaiian, or other Pacific Islander category, similar. There are specified subcategories that they could check the box, or they basically can do an other and fill in that. All of those are under consideration by the Bureau. Now, what specifically are they looking at? Let's look at the next slide, and that will tell us what, in fact, they're looking at. As to the new data points, or also here they entered any revised data point, what are the costs of collecting and reporting this information? And particularly, are the costs not justified given the benefit of collecting and reporting this information? So one thing the industry has been asking the Bureau to do is please consider cost versus benefits when adopting rules, and this is clearly doing that. So this is very welcome news. For the free-form text fields, solicit what are the costs to do this? What are the benefits of providing the information? I think a lot of statisticians are going to say the results are garbage. So any cost is not worth it because the results are garbage. So that's probably what we're going to hear on that. Are there other alternatives to it? So they're not just saying one or the other. They're saying, might there be an option as opposed to having it or not having it? So the Bureau here is being very political savvy. It's asking for options. Are there other considerations we should take into account? And here they say not just eliminate a new data field, that may not be on the table, maybe revising it would be the appropriate approach. Again, savvy, they're not saying all or nothing, they're looking for input on alternatives. And then particularly they're looking for in the last, hey, is there anything as to new or revised points where you need some more information or explanation from us to help with your compliance? So I think it's a very broad request. It's a very helpful request. It's a request that's probably going to garner a lot of comment that in many cases is opposed to one another. So with the comment deadline extended to October 15, I think that reflects, they realize people really want to spend time putting in good comments on this. So please do listen to the MBA when they ask for input. I don't think we're going to see a proposed rule probably until well into 2020. So when you look at when implementation, we are a long way from an implementation date. But when the proposed rule comes out, what I've often find is when the government thinks it's removing requirements that you can implement it really quick, we're going to have to remind them, yes, it's easier to remove, but that doesn't mean it's easy. It still takes time to implement. And that will be one comment we'll want to make sure to make when we get that. With that, I'm done with my portion. I turn it back to Jared.
Excellent. Thank you so much, Rich. And now we're going to turn back to California again and talk a little bit about where the crazy California courts have been going with negligence and how they're kind of coming to their senses. Valerie?
Thank you, Jared. My name is Valerie Schratz. I'm one of the partners at Hall Griffin. Jared's one of my colleagues, so I think all of you know him very well. We've had a little bit of success lately in the California Courts of Appeal, and so we wanted to share that this is good news for the industry, getting a little more clarity on some negligence issues and also some better rulings. So let's start with the next slide. Regarding all of you that work with loan originators, you will see negligence claims against originators, but not as nearly as many as we used to see. Most of those claims have to be brought within 1 to 3 years of the loan origination. The cases that we're seeing the vast majority of are usually after that time frame. So they're going after subsequent servicers and beneficiaries that took assignments and things like that. So we're seeing less on the origination side with negligence just based on that. mostly with negligence, it's usually listed in a complaint as something that's kind of a catch-all in addition to other statutory claims like the Homeowners Bill of Rights. And there's lots and lots of case law out there about how to deal with those statutory claims, but negligence has always been a bit murkier area, especially when it comes to loans. So next slide. In its bare bones, negligence cause of action really just has 4 elements to prove: duty, breach, damages, and causation. And when it comes to the pleading stage of a borrower trying to allege claims, they usually try and allege, very basic elements and facts to support each of these. And the one that we as litigators tend to focus on most is the duty element, because that's the one that's more of a legal issue. Can they establish enough facts to constitute a duty? So next slide. So when this area really first started getting developed, there was a couple of cases that came out that started talking about how financial institutions didn't have a duty in most circumstances when it was within the scope of their business. Basically, some of the early thoughts lended towards there are statutes that govern these things. This is really a business decision. If you didn't reach the statutes, we kind of leave the business decision to those who lend the money to make that business decision, and we don't disturb it. There's been some whittling away of that over the years, unfortunately. Next slide. One of the big cases that really started digging into that for lenders and loan servicers was the Luaris case. And Luaris basically looked into it and said, well, if we find that you're doing loan modification or other things that are outside of what we would call a lending institution's conventional role as a lender of money, then you may have a duty of negligence imposed. But there was still that basic backbone of the underlying rule is no duty unless you can find something really far and above and beyond a lender's usual business practices. So next slide. Then we start to see more and more cases where they're starting to find that duty. So the door was opened and a lot of cases started walking through it. Alvarez, Daniels, Rosetta, and then now Billings is a very recent case decided in January of this year that have all started to say, well, if you can allege some bad facts by the lender in a loan modification process or related to loan modification review, then there will be a duty imposed, which is interesting because most of the time when you talk about bad acts, that's usually what we refer to as the breach elements. But here, those bad acts are being used to justify whether or not a duty is actually imposed. Unfortunately, this conundrum isn't really recognized by the courts, and this test has adopted and been repeated and repeated over and over again. Most notably in the third appellate district where Rosetta and Billings have come out of, it's very much been leaning towards, well, allege any bad facts and we'll find a duty of negligence and allow the case to proceed to discovery and more factual stages, which, as many of you know, is the much more expensive part of litigation. Next slide. So where we found ourselves was getting in kind of a worse and worse situation of, at the beginning, we could usually get things kicked out saying, we've got this general rule that there's no duty, and finding that we're stuck in more and more litigation actions because more and more of these plaintiffs are alleging just a few bad acts and courts are finding a duty of negligence. There was some split among the districts. Like I said, the third was probably one of the worst. And then there were other districts who were trying to lean more towards back that old rule of, no, this is within a lender's discretion. This is their business judgment. We shouldn't disturb that if it's within the conventional role of a lender. So, and today there still exists quite a bit of split between the districts of what tests to apply, what bad acts are sufficiently bad enough to find a duty, and how to balance those. So to date, the California Supreme Court hasn't taken that up, but there's a lot of speculation that it's going to reach that point as this split continues to get worse and worse, and we see more and more of these cases where different tests are applied, different results based on similar fact patterns, things like that. So next slide. The good news is we are now starting to see cases very recently, this one just with a decision issued in June of this year, so just less than a month ago, talking about a little bit more clarity in the test. This particular case, Brian Wilson versus Specialized Loan Servicing, was decided in that bad third district. So the worst district for lenders to get these things out, and they're finally solidifying a test and finding that a lender didn't commit negligence. So in this particular case, we have a borrower who had a $604,000 loan default starting back in November 2008. Then we jump, he works with his first loan servicer for several years, can't get anything approved, moves on to a second loan servicer, Specialized Loan Servicing, in 2012. Mr. Wilson tries again, submits multiple applications. In this time, SLS does a really good job of, they review his applications, they get any missing documents immediately, all of them are deemed complete, and they issue decisions, but all those decisions are denied. And the denials all state that an affordable payment could not be determined based upon Mr. Wilson's inadequate income. Well, Mr. Wilson, of course, not very happy with this, files a couple of appeals. Again, SLS does the right thing, reviews the appeals, responds in writing, even makes SLS representatives available to talk to him. So here we think we have a really good case of what should be done is being done. Next slide. Well, Mr. Wilson, unhappy with these denials, says, well, we need to, I should be approved, that a former servicer was going to approve me based on the same income, and SLS's decision not to consider my income clearly has to be wrong. Additionally, it's income, they have to consider it, and thinks that this is a negligence violation. Mr. Wilson also, because of all these denials, then applies for some assistance with Keep Your Home California, which at that time had funding, and he was provisionally approved. SLS tells Mr. Wilson that he's provisionally approved, tells them he'll work with them, but unfortunately, about a month later, they learn the servicing is being transferred to another servicer. SLS's hands get tied. They tell the borrower, they tell Keep Your Home California, they say, okay, this is all being transferred, send everything to the new servicer. Again, we think we have here everything SLS should have done. Next slide. Well, being right doesn't keep you from a lawsuit, unfortunately. So Mr. Wilson sues SLS. He also sues the former and now current servicer, who are still up on appeals in other cases. He claims SLS had a duty under negligence to process his loan modification with the income he was claiming, and also to process that Keep Your Home California application, despite the fact that they no longer service this loan. As was the practice, and still is the practice of many lenders, SLS files multiple demurs, and he amends complaints. SLS eventually gets dismissal after demurs. Unfortunately, then Mr. Wilson appeals. Next slide. So just on June 24th, we received a wonderful decision from this third appellate district. Again, this is the same one that issued the earlier case Rosetta and then Billings just back in January. So we're talking less than a 6-month change from those prior cases over to this new one. The allegedly wrongful acts were reviewed under the balancing factors announced in the other case via Conja, and the court found that the mere fact that SLS agreed to review a loan modification did not automatically give rise to a negligence duty. This is pretty important because other cases have found in other districts that that is the case. If you agree to review a loan modification, you've automatically obligated yourself to a negligence duty. So it's important that this case found exactly the opposite. Additionally, they found that the refusal to consider that income was a business decision. This isn't something that was, them dropping the ball. This wasn't losing documents or other bad acts alleged in similar cases. This was SLS making a business decision. And the court said that's a normal activity of a lender, loan servicer, and we're not going to disturb that judgment. The court then went on to analyze the Keep Your Home California claims under those same balancing factors, noting specifically SLS had basically less than 30 days to do anything and couldn't have foreseen any harm in transferring these items to the new servicer, basically saying SLS did what it was supposed to do. We can't actually hold them liable under a negligence duty when we found they did everything right. Next slide. One key quote that I want to mention from that case that the court found was that the true nature of the duty Wilson seeks to impose is tantamount to a duty to approve his applications. I think this was a really strong statement from the court saying that, you know, a negligence duty is not a duty saying that the lenders have to do what the borrower wants. And I think that that's a quote that I'm certainly going to be using in future cases. This particular opinion is currently unpublished, but right now there's an application to have it published, so we'll see if that comes out. If it's published, it'll be citable throughout the state as reliable authority. Right now it's persuasive authority for any other court, and in the 3rd district at least, I know that they'll be looking at that. So next slide. While this is a great result, you know, and we hope that we can see more and more of these cases going forward, especially since this one came out of that really bad district for appeals, we know that there's still many cases that are continuing to work their way through the appeals courts and that they're still going to continue to have mixed results, whether or not they apply the same balancing test, whether or not they say that just because you decide to review an application means there's automatically a duty or not. Those things are still very different between the districts, and sometimes even within the same district, there's been differing authorities. The fact that there is these splits and that some of them are fairly extreme is something that is continuing to exert pressure on the California Supreme Court to clarify this. But to date, they still haven't done so, and so we're hoping that the right case ends up in front of them eventually to take a look at this. I think the big takeaway from this tip that we can see is that when, as a lender or loan servicer, you focus on ensuring that your processes are fast and correct, that the court's going to uphold that. And the court really focused, especially at oral argument, on the fact that SLS did everything it was supposed to. There wasn't the, you know, months and months of delays that we usually hear about from borrowers that just didn't exist here. And the court found that really important when basically allowing this lender to get out in a very early stage of litigation. One final note is that regarding the duty allegations, the fact that even they find a duty can be imposed doesn't necessarily mean a lender is going to face liability. It just means that unfortunately the litigation is going to continue beyond that point and unfortunately keep those litigation costs high until they can usually get it kicked out either through subsequent dispositive factual motions or at trial. As everyone knows, those are very expensive, and thus these pleading challenges are certainly going to continue as a more efficient way to try and get out some of these claims. So that was all that I have on that today, and I look forward to your questions.
Excellent. Thank you so much, Valerie, and of course, fantastic presentation by all of you. Thank you very, very much to Ken, Rich, and Valerie for your time. Dustin, I don't know if we have any questions or not.
Yeah, I've got a question here. The question is, and by the way, if anyway, we've got only a couple of minutes left, but if you'd like to submit a question, you can use the question module in the GoToWebinar setup there, and you can submit a question and we'll read it here. If you're going to do that though, do it right now. We're a little short on time. So the question is, since NMLS will be gathering data on how the MLO is paid, either W-2 or 1099, how do you see this impacting lenders or brokers in California, particularly those licensed under DRE? I'm not sure who wants to take that, but that's a question we've got so far. Well, hearing crickets, we'll gather that question. I can submit that to our speakers here and see if anyone has an opinion, and the person who asked that question, I'll respond to them personally and let them know. So again, if you have any other questions, I've got the contact information for our speakers up there, And then again, if you're interested in joining the committee, we'd love to have you join us. You have to be a member of the California MBA to be on our members only call that we'll be hosting here in a few weeks. And if you're interested in that, go ahead and email me. Other than that, Jared, I'll toss it to you to close this out.
All right, excellent. Once again, thank you so much to our speakers. These presentations I find are always incredibly valuable to share information amongst the industry and make sure we're all on the same page as to what's going on. Ken, thank you again for sponsoring this and for your firm's continued support of this committee. Again, I would reach out to anybody if you want to participate. Please let us know, and we would be happy to have you as members and participating in this committee to make it even better. Thank you again, everyone, for attending today, and have a wonderful weekend.
Thank you.